Of course, this docket that you've been talking about, it seemed like a rumor for some time now, but today we actually saw a file in possession of Advocate Mshololo as well as the state, introducing it now before the court. Your reaction?
Yeah, thanks, Leah. The 375 is not, it's a common cause. That docket was opened in 2019 by the investigating officer of the same docket, who initially they were together. They were a team of 4 before that docket of 375 was opened. So all of them, the Makubu and the Geninda, they were on 636. It was after a crucial statement was stolen out of 636 by one of them. Then that's when this second docket came in, because in the 375, there is an allegation of the defeat in the end of justice against one of the police officers. Hence, we've got the 2 dockets today.
Yeah.
Yes.
Advocate Teffo, I know in terms of the secondary dockets that you are in possession of, the state had requested this docket from the investigating officers, but it seemingly they did not want to give it to the state and they instead gave it to you. Why?
I'm surprised. I was not in today at the court. I was committed on other legal issues in the other court. Anyway, the court knew that from yesterday. Yes, so I was surprised when I hear my attorney explaining to me that today the matter has been postponed. We were expecting Mshololo to finish with Lucia today. Yes, so that the state can proceed with a re-examination if they do want to do one. So that maybe tomorrow we can proceed with a new witness. So it has been disingenuous of the state, in particular Advocate Baloyi, to say he just got the docket today. He knew the docket as far as 2020, January. Yes, that the docket has been there all along. And he does have that docket. Remember, we came late in the 2017. This year, on the 17th of March. That's when I get the disclosure. So the same time I get the disclosure, of both the 636 and 375. And on that day, on the 17th of March, Mr. Sibia was there, the attorney of Mshololo. So this story of not knowing the 375, I'm definitely surprised. It's bizarre, to say the least.
Yeah.
Yes.
Will you be pursuing your trial within a trial once more?
We were waiting for this witness to be finalized. So then, since this witness has not been finalized, under the pretext that Mshololo wants to acquaint herself with 375 contents, for which Baloyi gave her, for which I'm surprised as well. If both of them, they can say they were not aware of that, where did they get the file? And who can give me? Are they insinuating that people who are investigating 375 are colluding with me, or I'm in cahoots with them? Is what Baloyi is saying and Mshololo is saying. Definitely, that will be surprising. But as for what will be happening, because now, as I said, that my attorney told me that the matter has been postponed today to Monday, whereby I'm also told that Musia won't be there. So it's going to be something to say, what is the way forward insofar as this matter is concerned? So that's where we are going to take it from. Yes, because like I said, that I was expecting the finalization of a close examination of Mshololo on Musia. So then I will see what's happening on Monday.
So in terms of the 375 dockets, is your team pushing for those who were in the house to at least be charged or subpoenaed at this point?
As you say, that I'm the first one to introduce it. And then by the time when I brought Exhibit D and C, it was after, in one of my close examination questions, I asked Mr. Musia if he was aware of the existence of 375, for which he said he didn't know. Yes, and then that's when I brought Exhibit D, which is a Musia's affidavit. Remember, the reason to bring the Exhibit D is to remind Musia about the 375, and for the concession of contamination of the scene, for which, in the last paragraph, Musa has conceded to that. Yes, hence I say after he read that his own statement, he had a change of heart now, saying, no, yes, I want to believe that the scene has been tampered with. Yes.
What is the possibility of you calling your clients to defend themselves?
My client will defend themselves at the right time, if that time will ever come. Yes, because you'll remember that what is awkward is that
every legal practitioner to ensure that he or she is accountable on clients' funds. He is still expected to keep proper records, keeping of proper accounting records. It is not only for a legal practitioner who holds a Fidelity Fund certificate. Such is expected from all legal practitioners. This accounting recording underpins the rationale that the interest of the public must be protected at all times. Any failure to do so would be considered to be serious. It is paramount for a legal practitioner to ensure that the account is managed properly. The very essence of taking clients' monies should be risk mitigated. As alluded above, the issue of determination is whether the misconduct in question is so serious and of a nature that it manifests the lack of integrity, dishonesty, rendering him unfit to be a legal practitioner. In the belated affidavit of the respondent denies every allegation without any substantial evidence or effect. However, even when he made submissions from the bar, which is unorthodox in these proceedings, no evidence was presented to illustrate same. The fact remains he took money directly from the clients. Such monies were paid to him directly, others paid to other people's account. This court can safely conclude that this was misappropriation of funds, bearing in mind that no services was delivered or rendered by the respondent as expected. In our view, the misappropriation of clients' funds constitute theft, and the respondent further concealed this misconduct by manipulating clients in that he will assist them. This in itself portrayed dishonesty and lack of integrity on his part. This court is convinced that the applicant have laid sufficient grounds in striking off of the practitioner. Then this brings us to what the appropriate sanction would be. It was submitted that this misconduct warrants his removal. It was preferred as well by the applicant that this court could only order the suspension in exceptional circumstances. Therefore, this court is convinced that the respondent's conduct no longer meets the requisite threshold of a fit and a proper person. This court is satisfied that the applicant has proven its case on balance of probabilities, that the respondent is not a fit and a proper person, and that his countenance in practicing would involve danger to the public or the good name of the profession. The respondent had actually contravened, like I indicated, Section 37, subsection 2A of the LPA, and in that the respondent failed to cooperate with the LPC investigation. This court finds that the respondent misled the courts in a number of occasions. He was even contemptuous in a number of instances. The respondent breached the court order of Judge Fisher by threatening Colonel Smith and subsequently was arrested and released on bail. The respondent consulted with clients without acceptance of a brief from an attorney. Instead, he accepted the brief directly from clients, thus contravening Section 34, subsection 2A, I, and paragraph 27.2 of the LPC Code of Conduct. The respondent accepted payments directly from the clients without receipt or a brief from an attorney, thus contravening paragraph 27.4 of the LPC Code of Conduct. The respondent utilized attorney's details without their consent. The following order is made. 1. The respondent, Advocate Malisela Daniel Teffo, is hereby removed from the role of legal practitioners. 2. The respondent must surrender and deliver his certificate of enrollment as a legal practitioner to the registrar of this honorable court. 3. In the event of the respondent failing to comply with the terms of this order, detailed in paragraph 2, within 2 weeks from the date of this order, the sheriff of the district in which the certificate is be authorized and directed to take possession of the certificate to hand it to the register of the Honorable Court. The respondent is prohibited from handling or operating on his banking accounts used in receiving monies for the client. 5. Johan van Staden, the director of the Gauteng Provincial Office of the applicant, or his successor as such, in his capacity as such, be appointed as a curator, bonus, to administer and control the banking accounts of the respondent, including accounts relating to insolvent and deceased estate and any estate under curatorship connected to the respondent's practice as a legal practitioner, and including, if applicable, also separate banking accounts opened and kept by the respondent at the Bank of the Republic of South Africa.